The public present in the room and also those following us online. It is a pleasure and an honor for us here at the University of São Paulo Law School to welcome Professor Howard again here in our law school and talking today about the illegal occupation of the West Bank advisory opinion rendered by the International Court of Justice in July 2024. Among other qualifications and experience, Professor Howard had the opportunity of working in the case as on behalf of the Arab League, it was, yes. And then his thesis has been adopted by the court, which is something extremely and a great honor for a lawyer to have its statement accepted by the tribunal. So this is an opportunity we had. We started 1 hour before Professor Wilde joined us just now, talking about the two advisory opinions of 2004 and 2024, setting up some of the key issues that were brought, and also considering the 4 ongoing cases on genocide on the way in the International Court of Justice between Ukraine and Russia, between South Africa and Israel, joined by several other countries, including Spain and Brazil, the Gambia against Myanmar, and also Nicaragua against Germany. So it is something which maybe never happened before, that the ICJ has 4 ongoing cases on genocide. And at the same time, the issue is also being discussed in the International Criminal Court, which not only concerning Russian aggression against Ukraine, with 2 pending measures against President of Russia, Vladimir Putin, and Maria Lvova-Belova, and also against 3 officers of Hamas. They have been already, 2 of them definitively have been already killed, and the 3rd one has disappeared. So we may presume he may not be alive any longer. And also the Prime Minister of Israel, Netanyahu, and at the time, Defense Minister Yoav Gallant. So the matter of genocide is being quite present in the international agenda, and this is very worrisome. I don't know if you know that there is a permanent forum on genocide and crimes against humanity in the University of São Paulo. We have been organizing lectures since 2020. And we have Professor Eleni Klemeshev on Arab history of the Faculty of Philosophy and Human Sciences, and myself and Professor Artur Capella Giannatasio of the International Relations Institute, and also Dr. Felipe Alamino. We have been co-organizing these lectures in the format of the Permanent Forum on Genocide and Crimes Against Humanity. So it is a pleasure and an honor to have you with us, and you have the floor.
Muito obrigado. I want to express my warm thanks to Professors Eleni Klemeshev, Artur Giannatasio, Felipe Alamino, and Paulo Casella for their kind invitation and organization of this event. It's an honor to be back here at this great university, USP, and its law faculty here at Lago de San Francisco. On 19th of July 2024, the International Court of Justice issued one of the most, if not the most, significant judicial decisions ever rendered in international law. The landmark legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem, advisory opinion, what I will refer to as the OPT advisory opinion. Its main determinations were endorsed and supplemented by the UN General Assembly in a resolution of 18 September 2024. I represented the 22 states of the League of Arab States in the case as senior counsel and advocate. I was nominated to this role by the Palestinian human rights NGO Al-Haq, who I've worked with over the years as a legal consultant, and the Ministry of Foreign Affairs of the State of Palestine. In the same year, I also represented the League of Arab States and separately the Palestine Independent Independent Commission for Human Rights, the ICHR, before the International Criminal Court, the ICC, in the situation in the State of Palestine currently before that court. I also acted as senior counsel to the Gaza-based Palestine Center for Human Rights NGO, the PCHR, responsible for their written submission, forming part of the memorial, the written submission, of South Africa in the South Africa versus Israel case concerning the Genocide Convention before the ICJ. Last year, I represented the plurinational state of Bolivia as counsel and advocate in what was essentially a follow-up advisory opinion case to the 2024 advisory opinion on Israel's obligations to the UN, international organizations, and third states in relation to the occupied Palestinian territory. I also served as legal advisor to the Bolivian delegation in the emergency meeting of the Hague Group of States in Bogota. And I served as an expert witness on international law to the independent UK Gaza inquiry. Earlier this year, I represented the Palestine Independent Commission on Human Rights, the ICHR, at a meeting of the United Nations Human Rights Council at the United Nations in Geneva. Today, I'm going to speak about the 2024 advisory opinion. I must stress that I'm speaking entirely in a private individual capacity only, not also on behalf of any of the actors I've mentioned, or my university, or anyone else. That advisory opinion ended up being focused on what it called Israel's presence, i.e. the occupation, in the Palestinian territory it captured in 1967 and has controlled ever since, i.e. the remaining 22% of Palestine that was not under Zionist control after the State of Israel was proclaimed in 1948, corresponding to the land on the non-Zionist control side of the so-called Green Line, Armistice Line of 1949, the Palestinian Gaza Strip and West Bank, including East Jerusalem, commonly referred to as the Occupied Palestinian Territory, the OPT. Within what is therefore very limited focus, the court essentially addressed two matters of legality as far as Israel is concerned. First, is the way this presence is conducted lawful? And second, is the presence itself lawful? Of course, it would not be appropriate for me to seek to relitigate any of the matters I argued before the court, let alone to offer a critical appraisal of the opinion and the separate statement of the judges. I had the great privilege of being given the opportunity to influence the approach taken by the court and its individual members, and having had that, I must naturally accept the way things went. That said, as I will explain, as it turned out, things went well in terms of my arguments finding a home in both the main opinion and many of the separate statements. I'm able to reflect on the meaning and effect of these arguments because they were based on a series of ideas that originate in my own academic scholarship, which predate and ended up being adopted in this case, including in the opinion itself. What I want to do then is indicate the significance of the case with reference to these, my ideas. As an academic, I was in the unusual situation where I had written on the very issues that were to be determined in the case, and the members of the League of Arab States decided to adopt these ideas as their own and asked me to represent them in putting these ideas to the court for its adoption. Having been asked to do this by a Palestinian human rights NGO, Al-Haq, with the support of the Foreign Ministry of the State of Palestine. This was an immense privilege and responsibility, and I am and will be always humbled by it. Although then I wrote submissions, delivered oral submissions to the court in the capacity of the representative of the 22 states of the League of Arab States, every idea in those written and oral submissions had their origin in my own prior published work. The publications are: first, a book published by OUP entitled International Territorial Administration, How Trusteeship and the Civilizing Mission Never Went Away. Second, an article published in the Palestine Yearbook of International Law in 2021 entitled Using the Master's Tools to Dismantle the Master's House, International Law and Palestinian Liberation. Third, a related policy brief published through my university in July 2022 entitled The International Law of Self-Determination and the Use of Force Requires an Immediate End to the Occupation of the Palestinian West Bank and Gaza. Fourth, a legal opinion published in the run-up to the UN General Assembly voting to request the advisory opinion in December 2022 entitled Is the Israeli Occupation of the Palestinian West Bank, including East Jerusalem, and Gaza legal or illegal in international law? Fifth, an article published in the Journal of the History of International Law, also in December 2022, entitled Tears of the Olive Trees, Mandatory Palestine, the UK, and Accountability for Colonialism in International Law. Sixth, a related position paper co-authored with Shawan Jabarin, the head of the Palestinian human rights NGO Al-Haq, published in September 2023, entitled British Reparations Owed to the Palestinian People. This was also published as a blog post on Opinio Juris. And seventh, another blog post on Opinio Juris, drawing on ideas in the previous publications, published in November 2023, entitled Israel's War in Gaza is not a valid act of self-defense in international law. The arguments I made in these publications, which I will elaborate on today, were adopted not only by the 22 states of the League of Arab States, but also the General Assembly in asking the court to render the advisory opinion, and many of the states and international organizations in their written and oral submissions in the advisory opinion proceedings, in the advisory opinion itself, and many of the individual and joint statements of the judges, and in the General Assembly resolution adopted to affirm the findings of the opinion. What I will do today is set out these key arguments on the illegality of the occupation and the consequences of this for so-called third states, i.e. all other states in the world in addition to the states of Israel and Palestine. The affirmation and adoption of these arguments by many states and international organizations, the Court, and the General Assembly is why this advisory opinion is a landmark in constituting, as I say, one of the most, if not the most, important decisions ever issued by that court, the most important legal judgment on the question of Palestine issued by any court, and one of the most significant international law judgments that now form part of the canon of international law. I'll begin with the arguments I made about the occupation's illegality. I will then turn to the arguments I made about the consequences of this for third states. Beginning then with the arguments about the occupation illegality. The central argument I made in the Palestine Yearbook article, which was accepted and adopted by the General Assembly in the question put to the court and addressed by the League, Arab League, and many of the other parties in the case, and in turn the court, was that it is vital to address the illegality of the occupation in terms not only of its conduct, but also of its existence. This involves a complete paradigm shift from how the legality of the occupation has usually been addressed by most international legal experts and international and Israeli human rights NGOs, and many, particularly Western states, who tend to focus exclusively on issues of conduct only. Matters such as violations of international humanitarian law, including violations of occupation law, notably, for example, of the prohibition of implanting settlers and settlements in occupied territory, norms against racial discrimination generally and apartheid in particular, and violations of international criminal law only, and, since October 2023, genocide. They would ignore the elephant in the room. Why is Israel even there? And does it have any legal right to be there? Mostly ignored was the question of whether international law had anything to say on this fundamental question of whether or not the occupation should even be in existence in the first place, and, if so, what the law says on this existential question. In other words, only asking whether or not the conduct of the occupation is lawful, and not also whether the occupation is itself unlawful or lawful. Such a limited approach was followed despite the fact that the Palestinian people themselves had been demanding freedom from Zionist domination, not simply asking to be treated humanely within the context of that domination. The General Assembly had previously referred to the occupation of the OPT and the Syrian Golan Heights by Israel since 1967 as a violation of international law. But despite this, as I say, many, particularly Western states, international legal scholars, and international and Israeli NGOs continue to address the question of legality as if it only concerned conduct and not also existence. Asking the existential legality question is only the start of the analysis, because then it's necessary to clarify what law determines the answer to this question and go on to apply that law. The General Assembly might have already said that the Israeli presence in the OPT is illegal, but on what basis exactly? Presumably self-determination. But on what legal basis do the Palestinian people have this right? Presumably, the right covers the OPT. But is that the territorial limit of its application? Does Israel therefore not have any legal right to sovereignty over any part of the OPT, and if so, on what basis? What about the Balfour Declaration, League of Nations mandate arrangements, which the Council of the League of Nations purported to stipulate that the Balfour Declaration should be implemented in Palestine, thereby potentially vesting sovereignty over the entirety of Palestine in a future Jewish state. Moreover, even if the occupation is illegal in self-determination terms, might it be lawful on a different basis, as a means of self-defense for Israel, at least on a temporary basis? Assuming all these matters have been resolved and a conclusion reached as to illegality, what in particular does this mean for how and when the occupation should end? For example, even if the occupation must therefore end, can it at least be maintained until there is a peace agreement between Israel and Palestine that provides security guarantees to Israel? Might it also be lawful to maintain the occupation until the Palestinian people are deemed ready to run their own affairs? The General Assembly simply stating that the occupation is illegal did not by itself provide an answer to these and other fundamental matters. Nor had these matters been addressed either at all or at least properly in academic scholarship. It was this gap that I attempted to fill in my publications. And when the call came, I was able to take the answers I generated to the court, converting academic scholarship into court submissions. I'll now flesh out some of the particular problems with existing approaches to the question of the legality of the occupation, how I addressed them in my scholarship, and how the arguments I put to the court based on that work were adopted by it and the General Assembly. One predominant approach in the academic literature, which was put to the court by some of the parties, is that because the norms of occupation law presuppose that occupations will be temporary, somehow occupation law itself therefore contains a norm requiring occupations to be temporary. This is a non sequitur, making a category error in ascribing norms that regulate the conduct of an occupation the character of norms that would determine whether or not an occupation should be in existence in the first place. Moreover, by presenting this actually non-existent norm as exclusively determinative of the question of existential legality, such approaches also implicitly reject the relevance of the norms that actually are determinative of this question, to which I will return in a moment. In the Master's Tools article and legal opinion, and then in my written and oral submissions to the court, I explained why this view was mistaken. My position was adopted and affirmed by the court. Some parties in the case, such as France, agreed that occupation law is silent on whether or not occupations are lawful, and proceeded from that to suggest that also more generally, there are in fact no norms in international law concerned with this existential matter. What these parties ignored, but the court did not, was the argument I made in my publications and to the court, along with some of the other parties in the proceedings who had taken up my approach and adopted it as their own. This argument is as follows. Whereas indeed occupation law is not itself concerned with the existence of the occupation, there are other areas of international law which are so concerned. The law of self-determination and the law on the use of force. The court agreed, and when the president explained this as he read out the opinion, and I was sat right in front of him, I felt, as I did in many other moments, as if my own words were being read back to me. President Salam said, and I quote, "The court considers that the rules and principles of general international law and of the Charter of the United Nations on the use of force in foreign territory, jus ad bellum, have to be distinguished from rules and principles that apply to the conduct of the occupying power under international humanitarian law, jus in bello, and international human rights law. The former rules determine the legality of the continued presence of the occupying power in the occupied territory, while the latter continue to apply to the occupying power regardless of the legality or illegality of its presence. It is the former category of rules and principles regarding the use of force, together with the right of peoples to self-determination, that the court considers to be applicable to its reply to the first part of question B of the request for an advisory opinion by the General Assembly." End of quote. And that first part of question B being on the question of the legality of Israel's continued presence in the OPT. What then do these two areas of law say about the fundamental question of whether or not the existence of the occupation is lawful? Beginning with self-determination. Here, there is a series of arguments made by some academics and adopted by some states, notably Israel itself and some of its supporters, which had to be addressed. I covered these arguments in my academic work, and the approach I took on them, as set out in my submissions to the court, was adopted either explicitly or implicitly by the court in the opinion and by the General Assembly in its subsequent resolution. One argument is that advanced by Israeli scholars Orna Ben Naftali, Ayal Gross, and Keren Michaeli in an article in the Berkeley Journal of International Law of 2005, offering an argument as to why the occupation is legal. That article is one example of the mistaken approach I identified earlier, which the court, following my approach, rejected, of seeking to argue that somehow internal to occupation law are norms that, if violated, render the existence of the occupation illegal. In addition to the aforementioned mistaken idea that somehow occupation law itself requires an occupation to be temporary, rather than simply presupposing temporariness, the authors of this article also argued that the protective norms of occupation law constitute norms concerned with determination, and that, therefore, if they are violated, if an occupation is abusive, then the occupier has ceased to have a right to maintain the occupation. Thus, here, self-determination effectively means only the right to be treated humanely under conditions of domination. The authors go on to argue that Israel has indeed violated this norm, and therefore Israel no longer has the right to maintain the occupation, and instead authority should be transferred to an international authority, which presumably can be assumed to be willing and able to govern the Palestinian people humanely. This is not self-determination in its entirety. At best, it is internal self-determination, operating as some sort of equivalent to what is termed in international law remedial secession, i.e., a right of external self-determination, a right of international independence, for example, through statehood, that arises only and if internal self-determination is egregiously breached. Except here, there is no right to be independent, unlike in the doctrine of remedial secession. Rather, the Palestinian people must exchange dependency under Israeli domination for dependency under some form of international administration. As I argued in my book and in the Olive Trees and Esther's Tools articles, and I put to the court, this partial rendering of self-determination, when applied to a people who have a right to external self-determination arising out of the provisions of Article 22 of the League of Nations Covenant, and, in addition, by virtue of having been subject to colonial rule under the British Mandate, this is effectively a normatively anachronistic attempt to reintroduce the colonial doctrine of trusteeship over people, that external domination is not itself illegitimate, provided it's conducted in a humane fashion. This idea of replacing Israeli rule with a supposedly relatively more benevolent temporary foreign administration is, of course, at the heart of the idea implemented potentially through President Trump's Board of Peace administration of Gaza, possibly led by UK Prime Minister Tony Blair, former UK Prime Minister Tony Blair. Let me explain now why this would be illegal based on my academic ideas and how these ideas were adopted by the court in the advisory opinion. What I'll say now is explained in an article published on the 2nd of October 2025 in Middle East Eye. More than 2 decades ago, in the run-up to the 2003 Iraq War, a group of UK-based international lawyers, myself included, wrote a letter to then Prime Minister Tony Blair explaining that the war would be illegal under international law, and this was reproduced in the Guardian newspaper. Well, plus ça change, plus c'est la même chose. Again, warning of illegality is required for another global adventure, a foreign administration of Gaza, involving the same individual, potentially, this time somehow involved in the proposed protectorate alongside US President Donald Trump for President Trump's Board of Peace. The Gaza administration would replace the more than half-century occupation by Israel, which has involved serious violations of fundamental rules of international law in its conduct: racial discrimination, apartheid, torture, grave breaches of the laws of war, crimes against humanity, and genocide. At the heart of these rules of international law, regulating the conduct of the occupation, is the duty of trusteeship. Dominion by the trustee, Israel, should be exercised selflessly in the interests of the beneficiary, the Palestinian people of Gaza, not selfishly and abusively. There should be protection, not abuse. Befitting his role as an icon of Western liberal interventionism, Blair's association with the Gaza administration builds on the tradition of Western humanitarians who sought to humanize colonialism by grafting onto it a duty of care. As I argued in my book, this concept of trusteeship over people was adopted by Europeans for colonial rule over Africa at the Berlin Conference in the late 19th century, by the League of Nations after the First World War for the Mandate territories, including the British Mandate of Palestine, and by the United Nations after the Second World War for the Trust territories and all other non-settler colonies, referred to under the UN Charter through the euphemism of non-self-governing territories. Trusteeship assumes a world divided between childlike people incapable of looking after themselves, a characterization now applied to the Palestinian people of Gaza, and adults, such as Tony Blair, Donald Trump, etc., in the context of the Gaza trusteeship. who are deemed able to rule over not only their own people, but also others. Falling in the child category is the rationale for requiring trusteeship. In the League of Nations Covenant, the people of the mandates were, and I quote, not yet able to stand by themselves under the strenuous conditions of the modern world, end of quote. The child-adult relationship is the rationale for the duty of care. The adult is in charge, but must act in the interest of the ward. The adult's responsibility is to bring up the child so that it will eventually attain maturity, to conduct tutelage, enabling development. The Gaza trusteeship would thus, under this idea, supposedly be temporary, because it is transitional. The adults will build up local capacities for self-administration. The children will consequently mature and attain adulthood, and the need for trusteeship will end. At the heart of this model is racism. In the colonial era, a racist global standard of civilization, adopted within a system dominated by Europeans, determined who the adults and the children were. No prizes for guessing who conceived themselves as the adults. Trusteeship was a self-serving sham, invoked in bad faith, serving as an alibi to rationalize colonial rule, which could now be justified as a civilizing mission. But the consequence of colonial liberation struggles after the Second World War, the end of formal colonialism for non-settler colonies, was the adoption in international law of the right of self-determination. This was a repudiation of trusteeship. There were no more childlike and adult-like people in the world. The racist child-adult distinction between peoples was supposedly abolished. All peoples were equal and deserved freedom as adults. As the United Nations General Assembly stated in paragraph 3 of Resolution 1514 of 14 December 1960, and I quote, "Inadequacy of political, economic, social, or educational preparedness should never serve as a pretext delaying independence." Quote. Despite this, trusteeships continued, mostly conducted by international organizations, as in Bosnia and Herzegovina and East Timor. Global human rights rules were invoked as a seemingly non-racist standard of civilization that could determine legitimately where trusteeship was needed. International organizations were seen as capable of acting selflessly and thus performing the duty of trustee in good faith, in contrast to states. The US-led occupation of Iraq, bad. The UN in East Timor, good. And temporary arrangements, when actually followed, yes, East Timor, no, Bosnia and Herzegovina, were seen as somehow genuine trusteeships in that they didn't endlessly defer independence as sham colonial versions had. Western diplomats tell me that my book, which covered these and other arrangements, was used and is being used as their manual for the Gaza arrangements, including by the Board of Peace. This horrifies me. It is clearly based on a selective reading of the book, drawing on the earlier chapters that set out the different forms of international trusteeship, but ignoring the later chapters, which explain why, in the self-determination era since after the Second World War, trusteeship of this kind is incompatible with the legal right of self-determination, as reflected in that statement by the UN General Assembly, reflecting the position in customary international law made in 1960. In the advisory opinion proceedings, I argued for the League of Arab States, based on my academic research, that the Palestinian people had a legal entitlement to be free of the Israeli occupation without preconditions, simply because of their right to self-rule, not because they were being treated abusively. The court agreed. This was a conclusion about the right of self-determination, pure and simple, in and of itself. It would therefore apply equally to any form of foreign administration, however ostensibly humanitarian and time limited. Replacing an abusive state trustee with another form of somehow international trusteeship is not self-determination and would be illegal. A related argument, which has its origin in the work of another Israeli academic, Eyal Ben-Venisti, and was put to the court by those states supporting Israel, such as Fiji, the USA, the UK, and Zambia, was that an occupation can continue lawfully until there is a peace agreement. As I explain in the Master's Tools article, Ben-Venisti roots this norm that he claims exists in a statement made by international lawyer Hirsch Lauterpacht in the era before both external self-determination and the law on the use of force had come to have the meaning that they have had throughout the period of the Israeli occupation of the Palestinian territory captured in 1967. Also, Ben-Venisti inexplicably fails to give due account to the relevance of these norms to the question of ending the occupation, other than suggesting, without any authoritative grounding, that the significance of the right of self-determination is that the occupier must engage in a good faith negotiation for such a peace settlement, and that if it does not do this, then it loses the right to continue the occupation. Again, as I argued in the Master's Tools article, this is a wholly inadequate treatment of the right of external self-determination, which is an automatic right to freedom because the occupier has no right to exercise dominion over the occupied people. It does not depend on the conclusion of a peace agreement, or in Ben-Venisti's qualified approach, the failure of an occupier to negotiate such an agreement in good faith. Again, my view here was adopted by the court. When it then came to the question whether the occupation violates the right of self-determination, my academic argument, which was adopted by the current United Nations Special Rapporteur on Human Rights in the Palestinian territory occupied since 1967, Francesca Albanese, in her first report to the UN General Assembly in 2022, and was also the position I put to the court on behalf of the League of Arab States, and also advanced by some of the other participants, and was adopted by the court. The argument was that the occupation is existentially illegal as a violation of the right of self-determination of the Palestinian people and should therefore be terminated. I said immediately, the court said as rapidly as possible. The General Assembly said without delay and no later than 12 months from the adoption of its subsequent resolution that year. The expiry of that period is coming up to its one-year anniversary next month, September 2026. What then of the law on the use of force? The other area of international law which I argued and the court agreed is determinative of the question of the legality of the existence of the occupation. Again, my academic argument, which became the position I put to the court on behalf of the League of Arab States and was also advanced by some of the other participants based on my work, was adopted by the court. The occupation is existentially illegal as a violation of the prohibition of the acquisition of territory through the use of force. However, this is not the only basis on which the occupation's existential legality must be addressed when it comes to the law on the use of force. What I would like to do now is explain the wider basis of jus ad bellum illegality and how we can understand it as having been addressed implicitly in the advisory opinion judgment. As I said to the court on behalf of the League of Arab States, and the court affirmed, Israel's exercise of control over the Palestinian territory since 1967 as a military occupation is an ongoing use of force. As such, its existential legality is determined by the law on the use of force. What I want to address now, as set out in my academic publications, is the question of legality in the jus ad bellum as a general matter, beyond the specific issue of legality, the legality of the use of force to purportedly annex territory in particular. And the view that I set out now is contained in full detail in the Master's Tools article. It's necessary to recall that Israel captured the Gaza Strip and West Bank from, respectively, Egypt and Jordan in the war it launched against these two states in Syria. It claimed to be acting in self-defense, anticipating a non-immediately imminent armed attack. The war was over after 6 days. Peace treaties between Israel, Egypt, and Jordan were subsequently adopted. Despite this, Israel maintained control of the territory and continuation of the use of force that enabled its capture. Israel's 1967 war was illegal in the jus ad bellum, even assuming arguendo its claim of a feared attack. States can't lawfully use force in non-immediately imminent anticipatory self-defense. Moreover, assuming again arguendo that the war was lawful, the justification ended after 6 days. However, the jus ad bellum requirements continued to apply to the occupation as itself a continuing use of force. In 1967, with self-determination well established in international law, states could not lawfully use force to retain control over a self-determination unit captured in war unless the legal test justifying the initial use of force also justified, on the same basis, the use of force in retaining control. Moreover, this justification would need to continue not only in the immediate aftermath, but for more than half a century. Manifestly, this legal test has not been met. Israel's control over the Gaza Strip and West Bank through the use of force has therefore been illegal in the jus ad bellum since the capture of the territory, or at least very soon afterwards. The occupation is therefore again existentially illegal in the use of force, an aggression, this time as a general matter beyond illegality specific to purported annexation. What then Israel's military action in Gaza following the attacks of October 2023? This is not a war that began in October 2023. It's a drastic scaling up of the force already being exercised there and in the West Bank on a continual basis since 1967. A justification for a new phase in an ongoing illegal use of force cannot be constructed solely out of the consequences of violent resistance to that illegal use of force. Otherwise, an illegal use of force would be rendered lawful because those subject to it violently resisted. Circular logic with a perverse outcome. More generally, Israel cannot lawfully use force to control the Palestinian territory for security purposes, pending an agreement providing it with security guarantees. States can only lawfully use force outside their borders in extremely narrow circumstances. Beyond that, they must address security threats non-forcibly. A final potential basis sometimes invoked to justify continuing the occupation should be addressed. Occupation and human rights law oblige Israel to address security threats in occupied territory. However, they only regulate the conduct of an occupation when it exists. As I've indicated, they don't also provide a legal basis for that existence itself. Existential legality is determined by the law of self-determination and the jus ad bellum only. There is no legal backdoor basis for Israel to maintain the occupation through the imperatives of occupation and human rights law. Now, the court didn't pronounce on these questions of jus ad bellum illegality as a general matter, only addressing it as far as annexation was concerned, not therefore addressing in particular self-defense, although some of the judges did in their separate opinions. Instead, as I mentioned, the court focused only on jus ad bellum illegality arising out of purported annexation in particular. On the basis of finding this illegality, and the finding that the occupation constituted a violation of the right of self-determination, the court concluded that the occupation was existentially illegal and therefore should be brought to an end, as I indicated, as rapidly as possible. What I want to suggest is that this overall finding had to imply a determination on those general jus ad bellum matters, including the question of self-defense that I've just outlined. How do I say this? By disposing of the question of existential legality, having characterized the occupation as a use of force, the court necessarily had to have already dismissed the validity of any jus ad bellum justification, such as self-defense, for this use of force. Had it not done so, it could not have concluded that Israel had no right to maintain the occupation. The fact that the court did not expressly reject the validity of any jus ad bellum justification such as self-defense does not alter the fact that by characterizing the occupation as a use of force and determining that as such it was existentially illegal and therefore needed to end as rapidly as possible, this rejection was implied. Equally, although the court's determination of illegality in the jus ad bellum was specific to the issue of purported annexation, its overall finding of existential illegality applied to a presence it had expressly characterized as a use of force means of necessity that the occupation is a use of force that lacks a valid legal justification, and as such, as a general matter, is illegal in the jus ad bellum on this second general basis. Likewise, although the court didn't use the term aggression, the jus ad bellum violations it determined to be taking place, both expressly a purported annexation through the use of force and impliedly a use of force in the form of an occupation without valid legal justification. These violations are universally regarded to be paradigmatic examples of jus ad bellum violations constituting aggression. As indeed President Salam, as he was then, said in his separate opinion when it came to the annexation-related violation and the individual crime of aggression in the Rome Statute. In effect, then, Israel's use of force, enabling it to control the Palestinian Gaza Strip and West Bank, including East Jerusalem, since 1967, has been characterized as an aggression by the International Court of Justice. There is a question as to the relevance of the court's finding to the particular issue of the legality of Israel's military presence, through which it has used extreme force, constituting genocide, in the Palestinian Gaza Strip since October 2023. The OPT advisory opinion was requested by the UN General Assembly on 30 December 2022. The court stipulated a deadline for the written statements of participants of 25 July 2023. This was all then before the 7th of October 2023. The deadline for the written responses to the written submissions was 25 October 2023. When Israel's use of extreme force in Gaza began. That extreme use of force then continued throughout the period of the oral hearing, which was between 19 to 26 February 2024, and in the period between then and when the OPT advisory opinion was issued, 19 July 2024. Some of the written responses and oral statements made by the participants in the advisory opinion case, including the written response and the oral statement I made on behalf of the League of Arab States, expressly referenced the question of the legality of Israel's use of force in Gaza after 7th of October 2023, and the relationship between this and the legality of Israel's use of force there and in the West Bank since 1967, the argument I set out earlier. The question put by the General Assembly used policies and practices as a catch-all term for the behavior of Israel in what the court determined was limited to the OPT, the legality of which the General Assembly asked the court to determine. The court stated in the OPT advisory opinion that it, and I quote, notes that the request for an advisory opinion was adopted by the General Assembly on 30 December 2022 and asked the court to address Israel's ongoing or continuing policies and practices. Thus, the court is of the view that the policies and practices contemplated by the request of the General Assembly do not include conduct by Israel in the Gaza Strip in response to the attack carried out against it by Hamas and other armed groups on 7 October 2023. It might be thought from this statement that the court's determination that Israel's presence in the OPT is illegal only runs up to 30 December 2022 and is therefore without prejudice to whether or not circumstances after that date might lead to a different conclusion, notably when it comes to the legality of the presence in the Gaza Strip in particular. However, as I mentioned, the court followed its determination as to the illegality of Israel's presence with a consequent requirement that this presence needed to be brought to an end as rapidly as possible. The court could not have made this statement unless at the time when the OPT advisory opinion was issued, 19 July 2024, there was no lawful basis in the jus ad bellum for Israel to maintain its presence in the OPT, including the Gaza Strip. The implicit rejection of a general jus ad bellum justification for Israel to maintain its presence in the OPT, including the Gaza Strip, certainly applies then not only up to 30th of December 2022, of course preceded by a potentially 57-year period, but also on 19 July 2024. Equally, for the UN General Assembly, in its resolution affirming and implementing the OPT advisory opinion, to call on 18 September 2024 for Israel to end its unlawful presence in the OPT without delay and no later than 12 months from the adoption of the resolution, is the expression of a clear view that at that moment, hence, on the basis of its determination, backing up the view taken by the International Court of Justice, that the presence was unlawful. Hence, that presence being characterized as such, and hence the requirement that the presence must end without delay. Notably, the General Assembly follows this by stipulating, and I quote, that it demands that Israel comply without delay with all its legal obligations under international law, including as stipulated by the International Court of Justice, by, inter alia, withdrawing all of its military forces from the occupied Palestinian territory, including its airspace and maritime space. End of quote. What then of the consequences of the legality of the occupation for all other states? The fundamental character of the legal rules, the law of self-determination and the law on the use of force, violated by Israel in maintaining its illegal presence, means that all states bear special legal obligations to suppress these violations. These obligations are entirely separate from and more extensive than the duties they also have to suppress the violations of international law involved in Israel's abusive, discriminatory, genocidal treatment of the Palestinian people. They are also much more fundamental and wide-ranging, since they concern the very presence in the OPT in and of itself. So every aspect of it, including but not limited to its abusive, discriminatory, and genocidal conduct. In order to appreciate the nature and extent of these obligations, it's necessary to synthesize what has been said about them across a range of sources, notably the International Law Commission's articles on state responsibility and its draft conclusions on Jos Kogan's obligations, key General Assembly resolutions, the jurisprudence of the court, and academic scholarship. I provided this synthesis in my submission to the court for the League of Arab States, and the approach I advanced there was adopted by the court and the General Assembly. What I have to say about these obligations now is contained in full detail in an expert legal opinion I was commissioned to write for the NGO Al-Haq Europe, published in December 2024, which consolidates everything in the light of the advisory opinion and the General Assembly resolution. This opinion is now widely used by states, the UN, and other international organizations and NGOs as an authoritative explanation of this key matter. The legal opinion can be found online at the website of Al-Haq Europe in the Research and Publication section. The legal position is also summarized in an article I published in Middle East Eye on the 19th of September 2025. States are legally required to do three things. First, they must take positive steps, individually and collectively, to bring Israel's illegal presence in the OPT to an end. One option is to adopt sanctions against Israelis, including government officials involved in the conduct of the unlawful presence. This may extend to freezing bank accounts and assets abroad and travel restrictions. The second obligation is not to recognize the illegal presence as lawful. The third obligation is not to aid or assist in the maintenance of the illegal presence. This obligation is distinct from the more generally applicable, narrowly relevant rule from the International Law of State Responsibility, which covers any and all violations of international law by Israel, that a third state is legally responsible if it aids or assists Israel in the commission of one or more of these unlawful acts, and the aid or assistance is given with a view to facilitating that illegality. The issue here is different. It's a special obligation arising as a consequence of the fundamental nature of the obligations being breached. It is much more simply an obligation not to provide aid or assistance that will enable the Israeli illegal presence to be maintained. Pure and simple. Whether or not the intent behind this provision is to support illegality is irrelevant. As partly reflected in the ICJ's conclusion in the advisory opinion that Israel has purported to annex the OPT, i.e. that Israel treats the entirety of this territory as being under the overall seemingly indefinite dominion of the Israeli state, the Israeli presence in the OPT is linked to the Israeli state, including its military and the Israeli economy and society, including cultural, sporting, and educational life, in a complex and multifaceted manner, so as to make things factually and legally inextricable. The presence is conducted by the Israeli armed forces as part of their general operations. Israeli settlers living in the OPT, roughly constituting approximately 7.5% of the Israeli citizenry, often work in Israel, including for private Israeli companies, the Israeli state, and Israeli universities. Their commute between the settlement home and the Israeli workplace being facilitated by the settler-only roads and checkpoints linking the settlements to Israel, and in the case of East Jerusalem, the light rail which connects East and West Jerusalem, with a stop at the train station in the latter place, where the train then connects to the airport and major Israeli towns and cities, including Tel Aviv and Haifa. The housing of these citizens, these settlers outside of Israel, on land and using natural resources that have not been paid for, and where the usual costly requirements of environmental protection are typically disregarded. For example, raw sewage from settlements is routinely discharged onto nearby Palestinian villages. This constitutes effectively an economic benefit with effects in Israel to the general economy, the Israeli state, and the employers of settlers. Housing pressure, and so housing costs in Israel are reduced. Wage pressures in Israel are reduced insofar as cheaper housing enables employees to be paid less. The considerable economic activities performed in settlements, which are in some cases farms, factories, chemical and public utility plants, quarries, etc., are typically conducted by Israeli companies as part of and linked to overall activities of these companies taking place within Israel. The operation of public utility plants in the OPT that serve Israel, such as sewage treatment plants, without having to follow the same environmental safeguards that would be necessary were those plants to operate within Israel, reduces general utility bills in Israel. As for universities, Ariel University is located in the West Bank. The main Mount Scopus campus of Hebrew University is partly located beyond that green line that I mentioned, i.e., outside of Israeli territory in occupied East Jerusalem. These universities and the other Israeli universities located exclusively in Israel are, also in the case of Ariel and Hebrew universities, linked to the presence in the OPT in the sense that they train members of the Israeli armed forces, people who are, for the reason I mentioned earlier, invariably going to be using this training in their work as part of maintaining the presence in the OPT, and are also engaged in various other activities to support the illegal presence, and sometimes also adopt official positions affirming the legitimacy and the legality of all or part of that presence, whether in general or also more specifically by affirming the unlawful claim to sovereignty. So, for example, Hebrew University's official position that East Jerusalem is part of sovereign Israeli territory. As for culture and tourism, the old city of Al-Quds, Jerusalem, of course, one of the most important visitor attractions in the world because of its significance to the three main Abrahamic religions, is located in the OPT in East Jerusalem. Tourists must accept and work through the Israeli exercise of authority there, which is performed, of course, on the unlawful basis that it forms part of the sovereign territory of Israel. They often stay in Israeli-owned and operated hotels located on stolen Palestinian land in East Jerusalem. These hotel chains also operate in and house the same tourists in other tourist spots in Israel, such as Tel Aviv, and Israeli tour operators typically run tours that combine attractions in both Israel and the old city of Al-Quds. Many museums in Israel contain artifacts taken from sites in the OPT, including the old city of Al-Quds. In these and other key respects, the tourist and hospitality industry operates seamlessly across Israel and the old city part of the OPT, with tourists to Israel inevitably participating in this overall structure, even if they restrict themselves to territorial Israel, which few do, given that this would exclude the old city of Al-Quds. Consequence of all this is that when it comes to the behavior of third states and all other actors, including tourists, in their relations with the Israeli state, including the Israeli military, the Israeli economy, and other Israeli actors, including Israeli companies, including oil companies and universities, it is impossible, because of the way things operate, to meaningfully disaggregate relations that are one way or another connected to the Israeli presence in the OPT and relations that are somehow entirely free of such a connection. This problem is illustrated in the following observations made by the scholar Yusuf al-Tamimi in connection with that third duty I mentioned, the obligation not to aid or assist. Observations al-Tamimi made in a blog post on the EGIL Talk website, published on the 30th of July 2024, which I quote in my legal opinion, and I will quote here. So, in the words of Al-Tamimi, separating trade relations with Israeli businesses from links to the illegal occupation is difficult and sometimes impossible. Arms, drones, and surveillance equipment developed by Israeli arms manufacturers are employed throughout Gaza, occupied Palestinian territories, and East Jerusalem, and sold as battle-tested to European countries. Such economic activity clearly assists in the maintenance of the illegal situation and is thus prohibited under the ICJ opinion. This problem has proven persistent in economic relations with Israel. Other such examples include cooperations with Israel's National Water Company, which expropriates water from Palestinian springs in the West Bank, the country's largest supermarket chain, which operates in illegal settlements, and an irrigation firm. There is a difficulty in separating trade and investment relations with businesses operating in Israel and those having ties to occupied Palestinian territories, because Israel treats settlements as an integral part of its territory in accordance with its domestic law. With so many businesses tied up in internationally prohibited activities, it is indeed a question if untangling these activities from the illegal side of their activities is possible. Recent official documents obtained by a Dutch rights group through a Freedom of Information request show Dutch Foreign Ministry officials expressing doubts that any trade with Israeli businesses can be entirely settlement-free. And again, quoting from that report, almost every Israeli business has a connection to settlement somewhere. And that's the end of the quote from that blog post by Yusuf Al-Tamimi. Insofar as third states bear obligations applicable to their relations with Israel as a consequence of the legal nature of Israel's presence in the OPT, these obligations have to address those relations as a general matter. With arms, for example, there is an obligation not to provide any support to Israel whatsoever, not just support that might end up being used to commit genocide, war crimes, or crimes against humanity, since any support given is going to end up supporting the existence of the occupation one way or another. Likewise, when it comes to economic relations, both the OPT advisory opinion and the General Assembly implementing resolution stipulated an obligation to abstain, and I quote, from entering into economic or trade dealings with Israel concerning the occupied Palestinian territory or parts thereof, which may entrench unlawful presence in the territory, end quote. Given how, as I've indicated, the economic dimensions of the Israeli presence in the OPT are inextricably linked to the Israeli economy generally, this stipulation means that all economic and trade dealings with Israel concern, one way or another, all or parts of the OPT, and therefore all such dealings may entrench the presence. In consequence, states must adopt a comprehensive reciprocal trade, including arms finance, investment, scientific, technological, audiovisual, cultural, including tourism, educational, and sporting embargo against Israel, including but not at all limited to an embargo of products from settlements. Despite the ruling of the court and its affirmation by the General Assembly, there is still a seemingly widespread denial about, or at least refusal to acknowledge, these fundamental legal issues, both the existential illegality of the occupation and what this means for the behavior of all states and the international organizations they are members of, even on the part of those states who voted for the General Assembly resolution that set these issues out. Even the focus on genocide in the Palestinian Gaza Strip, which is of course necessary, by itself obscures the fact that even if Israel was not committing genocide, which it is, even if it was still behaving entirely humanely towards the Palestinian people, its presence would still be a breach of fundamental legal obligations, and states would still bear the fundamental obligations I've mentioned to bring these breaches to an end. With the second duty I mentioned then, the duty of non-recognition, for example, what is needed, as I argued in the Master's Tools article and the associated policy brief, is a profound shift of emphasis from an assumption that Israel's exercise authority in the OPT is valid and focusing only on whether or not in exercising this authority, Israel behaves in a way that is compatible with the international law rules governing conduct of the occupation, such as the rules of IHL and human rights law and the prohibition of genocide. This assumption is contrary to the legal position on invalidity, and adopting the approach is therefore a breach of the obligation of non-recognition of this invalidity. Put differently, it's a breach of the obligation not to treat the presence as valid. States must therefore shift emphasis from non-recognition of the legality of illegal conduct only to also non-recognition of the legality of the presence itself. Moreover, this includes a duty not to recognize as valid Israel's justificatory claims, whether expressly or impliedly, for its presence in the OPT. Any state that continues to affirm that Israel has a right to be present in any part of the OPT, including the Gaza Strip, on the basis of a right to self-defense, is breaching this duty of non-recognition. The time is long overdue for all states to face up to the exceptional character of Israel's violations of fundamental legal obligations in maintaining its presence in the occupied Palestinian territory, and the exceptional consequential legal duty they have to suppress this. Legally, they are not disinterested bystanders, free to pick and choose whether and to what extent they address the illegality of Israel's presence. They are required to act, and in doing so, must be comprehensive in what they address. Thank you.